Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about cruel and unusual punishment. Cases that should have gone to the Supreme Court of Canada, but didn't. In Quebec, a contractor was working without a contractor's license. This isn't generally unheard of, and Quebec law imposes a penalty of over $30,000 as a minimum fine for doing contractor work without a license as a contractor. The individual in this case received that fine and challenged it on the basis of the fact that the fine itself constituted cruel and unusual punishment. The court dismissed his arguments that his charter rights were being violated, determining that a fine of $30,000 didn't constitute cruel and unusual punishment. And this raises a really important question. Although cruel and unusual punishment often refers to the imposition of lengthy prison sentences and is used as a method to attack mandatory minimum jail terms in criminal cases, huge fines can effectively have the same result as criminal sentences for jail. Huge fines can prevent people, if they're owing to the government, from obtaining driver's licenses, which may render people stuck at home. They can prevent people from obtaining public services, which may prevent them from engaging in society in a more meaningful way. Huge fines can have a significantly detrimental impact on people's lives. They can amount to a de facto jail sentence. Even the Supreme Court of Canada recognized that in looking recently at the mandatory victim fine surcharge and determined that that was cruel and unusual punishment and unconstitutional. So how does a $30,000 fine imposed as a mandatory minimum fine differ in any way? And can provinces even impose these significant fines without having an opportunity for the courts to take into consideration the personal circumstances of the offender and their ability to pay? The reality is that these fines are as important as the victim fine surcharge, and the Supreme Court of Canada should have stepped in to expand the analysis of the Section 12 cruel and unusual punishment prohibition to circumstances where significant fines are imposed on people who have no ability to pay them. Unfortunately, the Supreme Court of Canada missed that opportunity to make the imposition of fines more tailored to the circumstances of the individual offender, which is what the sentencing process is supposed to be about in any event. It'll take another case, another significant fine, and numerous people suffering financially as a result of imposition of fines before the Supreme Court of Canada has the opportunity to right this again. You're watching Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting these videos together, and like, subscribe, and share with your friends.